Great. Thank you, Madam Secretary. Good morning, everyone. This is the meeting of the Executive Committee of the State Bar of California. This is November 18th. It's a regular meeting for us. For those of you who are joining us electronically, board members, welcome. It looks like it's Hai-Lin Chen, the lone wolf up there on the screen. Good to see you, Trustee Chen. I'll call the meeting to order and ask the Secretary to please take roll.
Chen.
Here.
Laris.
Here.
Delenn. Sowell. Stallings.
Here.
Duran.
Here.
We have a quorum.
Thank you, sir. This is the opportunity for members of the public who wish to address the Executive Committee on any item of business in the committee's purview to do so. You may indicate your interest in speaking by raising your hand on the Zoom function, which should be a toggle at the bottom of your screen. If you are joining us by telephone only, it is *9 to raise your hand. We'll give you a few minutes, or excuse me, a few seconds to make that indication of interest if you'd like to address the committee.
It looks like we have a caller who is interested in speaking.
Great. Caller, once your microphone is activated, you will have 2 minutes to address the committee. Thank you for joining us.
So for the caller from area code 415 that I have with a hand raised, your mic is available.
Am I unmuted?
You are now unmuted. You have 3 minutes.
Yeah, I would like to, first of all, object, if that's the proper term, in that I had submitted comments to the board through letters and such delivered to, I forget the gentleman's name, your chief administrator. That said, I'll just go with the comments that I would have made. As to the amendment to 2201, it's unclear how that would affect the possibility that there might be, I'll call it blowback, from the LA Times versus State Bar litigation. And what I mean is, if the case comes back and it opens the door to information available to the public that would show that there might have been some malfeasance on the part of the Office of Chief Trial Counsel, then the question is, does it make it easier for the Office of Chief Trial Counsel to essentially investigate itself? In another matter, the resignation of Kenneth Skiersey, also, I feel that there should have been some indication as to whether it would make it easier, right, for the Office of Chief Trial Counsel to essentially investigate itself, and which would sort of stop the public from getting the information that I feel is deserved to them. I'll also say, as far as the requested change to the felony posting on the State Bar website, that would be completely improper. It should be quite obvious to anyone who practices criminal defense or criminal law that a felony is quite different in superior court as it would be in federal court or in a different jurisdiction. There is a explicit reason why the State Bar was allowed to list felonies in superior court versus a felony in federal court. A felony is not a felony in federal court. In fact, anything in federal court is just a federal charge other than an infraction. So it would be completely improper to change the State Bar profile in that manner. In addition, I will also sort of note that several comments that I would have made concerning the State Bar's flagrant disregard to a rule, a business and professions code, which explicitly states that the State Bar shall not seek or obtain mental health records of licensees or applicants. And it's extremely important because the State Bar has been doing so with the participation of the Office of Chief Trial Counsel. And so then again, it's important it's important that there needs to be an investigation, or that the investigation into these areas, the Searcy, the LA Times, the Girardi, and into the state bar, allowing for the state bar to look into mental health records. In all of those areas, there needs to be a complete investigation, and it's questionable whether the amendment to 2201 would allow.
Thank you, caller. You're not required to do this, but if you'd like to, you can identify yourself for the record, and your name will be noted in our minutes. I'll give you that opportunity now. I will let you know that your comments have been heard by the committee and will be included in the record. Do you care to identify yourself?
Daniel Everett, licensee 268967.
Thank you, Mr. Everett. Appreciate you joining us. Is there anyone else who wishes to address the committee under public comment? Okay, seeing none, we are going to move through our agenda. The first item on the agenda is the chair's report, and that is my opportunity to just check in with the committee, let you know what has been going on from a high level. Truthfully, many of the things that I would normally address are agendized for several of our other meetings later in the day. So I will take the executive committee's time just to update you on our planning for the strategic planning process itself. The consultant that has been engaged by the bar has, by this time, I'm sure, met and spoken with each of the trustees and other stakeholders, probably not all the stakeholders yet, and probably not all staff members who were identified as part of that process for the planning session in January. But I understand things are proceeding very smoothly. Certainly appreciate the time and the effort that all of you have put in to speaking with the consultant. And if there are anything, any issues that you have not had a chance to raise with them that you would like to bring to either Brandon or myself, please feel free to do so by email or otherwise. And that's really all that I have to report for the executive committee. Happy to answer any questions if anybody has them. Okay, seeing none, let's move on to our business. Item A is the annual recommendation for appointment and reappointment of fee arbitrators, appointment of presiding arbitrator and assistant presiding arbitrators. And Mr. Tuff or Ms. Liu, please inform the committee.
They're joining now.
They're getting online, so we'll give them a few seconds. Okay. There's Andrew. Good morning, Andrew.
Good morning, everybody. Can you hear me okay?
Yes, we can.
Okay, great. So this item presents the annual recommendation for appointment and reappointment of arbitrators to hear fee disputes through the State Bar's mandatory fee arbitration program. This item also presents the annual recommendation for appointment and reappointment of the presiding arbitrator and 2 assistant presiding arbitrators. And with me this morning is Isabel Liu. She's the attorney for the mandatory fee arbitration program and our resident expert in all things mandatory fee arbitration related. Although this item involves only a short presentation, we're both going to share that responsibility this morning, and Isabel will present first.
Hi, good morning, everyone. As Andrew said, my name is Isabel Liu. I am an attorney with the Mandatory Fee Arbitration Program, which is under the umbrella of the Office of Professional Competence. So this agenda item has several objectives. I will be speaking about the first 2 objectives. So first up, this is our annual appointment and reappointment agenda item. And our first objective is to reappoint all of our current fee arbitrators. So presently, we have approximately 415 attorney and non-attorney arbitrators throughout the state. They are appointed for a 1-year term that is subject to annual reappointment, which is usually done during the November board meeting. So attachment A has a list of the 415 current arbitrators that are being recommended for reappointment. The list has been checked to remove the names of attorney arbitrators who are not currently active and eligible to practice law, as well as any attorney arbitrators who may have public discipline. So we are recommending the 415 arbitrators who appear on attachment A for the 2022 calendar year. Next up is the appointment of new fee arbitrators to the State Bar program. We have a list of 9 applicants for your consideration that we are recommending for appointment to the fee arbitration program. The 9 applicants consist of 8 attorneys and 1 non-attorney. All of the applicants were checked to make sure that they meet the minimum qualifications for service, and the attorneys' names were submitted to the Office of Chief Trial Counsel to make sure that they didn't have any public reportable actions. For the 1 non-attorney applicant, we conducted an internet search to make sure that there wasn't any information readily available that would suggest that appointment would be inappropriate. And a list of all 9 applicants that the program and the presiding arbitrator are recommending for appointment are on attachment B. So now we are at the final objective of the agenda item, which is the appointment of the presiding arbitrator and the 2 assistant presiding arbitrators. So I will hand it back to Andrew.
Thanks, Isabel. So previously, the Committee on Mandatory Fee Arbitration processed the appointments for the presiding arbitrator and 2 assistant presiding arbitrators. In 2019, following the 2017 Task Force on Governance in the Public Interest and the Board of Trustees Appendix I review, the Board of Trustees retired the Committee on Mandatory Fee Arbitration and transferred this appointment function to staff. In 2019 and 2020, staff was greatly benefited from the fact that all of the 3 members, the presiding arbitrator and 2 assistant presiding arbitrators, each sought reappointment for the last 2 years. However, earlier this year, the presiding arbitrator informed staff that he would not be seeking reappointment. And so as a result, this is the first year that staff is processing filling a vacancy in one of these 3 positions. And because the presiding arbitrator position requires experience in and specialized knowledge of mandatory fee arbitration laws and rules, as well as to ensure continuity with the State Bar Mandatory Fee Arbitration Program's operation, staff believes and strongly recommends that one of the current assisting arbitrators be first consulted to be appointed as the presiding arbitrator, as they would be in the best position to fill that role. And as a result, staff reached out to the 2 assistant presiding arbitrators to see if either or both of them would be interested in serving as the presiding arbitrator. And Clark Stone, one of our current assistant presiding arbitrators, informed staff that he would be willing, ready, and able to serve as the presiding arbitrator. And Lee Strauss, the other assistant presiding arbitrator, informed staff that he would like to continue to serve as an assistant presiding arbitrator. And so as a result, staff is recommending Clark Stone to be appointed as the presiding arbitrator and Lee Strauss to be reappointed as the assistant presiding arbitrator. And this has created a vacancy in the remaining assistant presiding arbitrator position. And so in order to fill this vacancy, staff sent an email to all currently appointed arbitrators to the State Bar's Mandatory Fee Arbitration Program. This email stated and informed the recipients that there was a vacancy in the assistant presiding arbitrator position for the 2022 calendar year, and requested that anyone who would like to be considered for appointment to this position submit a statement of interest along with their resume. Staff received a response from 10 interested persons, and we carefully considered each of them. Following our review, we are recommending the appointment of Summer Nastich as the assistant presiding arbitrator. She is an active arbitrator in the State Bar's Mandatory Fee Arbitration Program, and she will enhance the program by providing geographic and gender diversity to these leadership roles that guide the program. Lastly, this item also requests approval from the board for the process that's outlined in the agenda item for filling a vacancy in the presiding arbitrator or assistant presiding arbitrator position. Approving the process will, as outlined in the item, is going to help staff when processing these appointments in the future. And the process is much like I just described to you, first going to the assistant presiding arbitrators if there's a vacancy in the presiding arbitrator position, and soliciting interest from our current roster board appointed arbitrators to fill any vacancy in an assistant presiding arbitrator position. And with that, Isabel and I are happy to answer any questions you might have.
Thank you, Mr. Tuff. Ms. Liu, any members of the committee have a question for staff on any of this? Seeing none, I will ask a question, and that is, I don't know whether any of the individuals who've been identified, either as the chief arbitrator or assistant arbitrator, I know I got those titles wrong, but if any of them are here at the meeting and would like to address the committee, certainly we would love to hear from you. Mr. Tuff, do you know if that's the case?
I don't know if anyone's present.
Trustee Sowell.
I just have a quick question about the number of arbitrators. Is obviously we've added more. Is there a number that we're sort of pointing to that is sort of a target to have a sufficient number of arbitrators throughout the state? I'm just wondering what sort of the right balance is here.
Isabel, you want to take a stab?
Sure, yeah. I can answer that. We can never have enough fee arbitrators. They are volunteers, and we have 58 counties in California. And in theory, a fee arbitration or a fee dispute could arise in any one of those counties. So, the more the merrier. There is no target number, but they tend to be clustered in the large metro areas in the Bay Area, in LA and San Diego, for example. But we need arbitrators in every county, including north of the Bay Area, especially. So we don't have a target, but all are welcome as long as they qualify and meet the minimum guidelines.
Thank you, Mr. Trustee Sowell. Any other questions? Okay, I have some commentary and then a question, and that is, in reviewing the agenda item and looking at the resumes of the proposed presiding arbitrator and assistant arbitrators, and the people who actually applied for those positions, it's clear that there are a lot of very hardworking volunteer lawyers in the state with respect to this important program. Certainly, when there are fee disputes, those are important issues for the parties that are involved. And so, on behalf of the Board of Trustees, I want to thank the people that were being appointed today and reappointed for your service in this important way. I had a question actually about two of the identified arbitrators, last name of Scott. One is from Riverside and one is from Redlands. And I think that those gentlemen may be twin brothers because their bar numbers are 1 digit apart. And I am a twin myself, and so I thought that was an interesting tidbit of information. And if they are indeed twin brothers, my hat's off to each of them. And with that, I will take a motion.
Mr. Chair, so moved. Second.
Motion by Stallings, second by Cisneros. May we have the roll, please?
Chen.
Yes.
Cisneros.
Aye.
Delenn. Sowell.
Aye.
Stallings.
Yes.
Motion carries.
Thank you all. That will go to the full board with unanimous recommendations from the executive committee. Item B on our business agenda has been pulled for consideration. It will not be considered here at the EC or at the regular board meeting this afternoon. Item C is recommendation to amend the charter of the RAD committee. Mr. McLeod, it says you only need 5 minutes, and I'm impressed.
Thank you, Chair Duran. It's a relatively straightforward item, so I don't think you need to be impressed. It's a proposal here to amend the charter of the Committee on Regulation and Discipline. The amendment is designed to enhance, strengthen the oversight of the Chief Trial Counsel, and specifically, the amendments would put in place 3 changes to the charter in terms of oversight by the Board of Trustees and the Regulation and Discipline Committee over the Chief Trial Counsel. Those changes would be to put in place a performance plan of the Chief Trial Counsel within 90 days of hire and within 90 days of the anniversary date of the hire thereafter. To conduct a performance evaluation based on that performance plan by an outside independent consultant, which would include a self-evaluation by the CTC and feedback from peers and subordinates. And then the third element of the oversight, the strengthened oversight of the CTC, is to set up quarterly meetings between the chair and vice chair of the Regulation and Discipline Committee, which would involve the review of metrics that would be presented to the CTC, the chair and vice chair of RAD, by the executive director of the State Bar. So those are the proposed amendments to the charter of the Regulation and Discipline Committee and are laid out in the agenda item.
And just to clarify, Chair Duran, this agenda item codifies concepts that were put forward to RAD at, I believe it's July meeting or perhaps September meeting. So this was fully vetted by RAD and now we're just capturing it in the charter.
Thank you for the clarification. I thought that as I reviewed the materials. Mr. McLeod, do you have anything further?
I do not.
Do any members of the committee have a question, any questions for Mr. McLeod or Ms. Wilson?
Mr. Chair, just a comment.
Sure.
I would just echo what Ms. Wilson said about this codifying the very important discussions that this board has wrestled with. And really, I think is a testament to this board's responsiveness to different things that we've had to look at, really take this an introspective look at how we govern and how best to govern. And this really is, I think, an important step forward. So hats off to staff for starting this, I guess, pushing this boulder up this little hill. So we'll see how far it goes.
Thank you, Trustee Stallings. Trustee Sowell.
A quick question. If I remember correctly, when I take a look at this item, there is a need to contract with an independent sort of consultant to do some work relative to this. And I was just, there wasn't a cost associated with that. And I'm just wondering whether or not I could get a sense of how much that is.
I can provide that. That particular aspect of this proposal is not new, meaning we have conducted an evaluation of the Chief Trial Counsel annually, perhaps during the long recent interim period. That did not happen. And when we have done so, that work has been contracted out. Typically, the cost of the external evaluation is between $20,000 and $30,000.
Thank you.
Any other questions? I would just like to piggyback on what Vice Chair Stallings said. Not only hats off to the staff for putting this together so well, but hats off to you, Brandon. Many of these changes went through RAD under your leadership, and I know that it was a lot of work. There was a lot of, I think, good back and forth conversations with as she walks in the door, Ms. Lawrence and her staff were talking about the proposed changes to the RAD charter. So your timing is good. And that's just my commentary, just that this does represent quite a bit of significant work. And I think some very good proposed changes to the structure to ensure greater board through the RAD oversight of the Chief Trial Counsel's office, which is something that, I think plenty of folks in the legislature and elsewhere expect and want to see. And I think our licensees should also take some comfort's not the right word, but should view this very positively as best practices and fine tuning what the bar does with respect to the Chief Trial Counsel's office. So with that, if there are no further questions or comments, I would like to hear a motion, please.
Stallings, so moved.
Motion by Stallings.
I'll second.
Second by Cisneros. May we have the roll, please?
Shannon.
Yes.
Cisneros.
Aye.
Delenn. Sowell.
Aye.
Stallings. Yes. The motion carries.
Thank you, Mr. McLeod. Thank you, members of the Executive Committee. There is nothing further on our agenda. There is no closed session. So at this point, we'll adjourn and reconvene at 11 a.m. for the RAD committee. Thank you.